Lawyers. What were your "this guy isn't winning" cases? Story 1. A friend who is a criminal defense attorney was called at around 3 a.m. by the presiding judge. The sheriff is on his way to arrest your client, who is having his bond revoked. I am calling you at 3 a.m. about that because he is having his bond revoked for posting a real name social media thread directed at me and my family. Story 2. I had a client tell me she couldn't be charged with drunk driving because her boyfriend was steering from the passenger seat and she was just working the pedals. I passed that consult on to someone else with no shame. Story 3. My mom told the judge during her DUI appearance, "Your Honor, I've been driving drunk most of my life and this is the only time I've been caught, so I think I'm a pretty good drunk driver." Comment 1. I got into a car accident when I was 19. I did some safe driving course and I was surprised that almost everyone else in that class seemed shocked that getting behind the wheel while under the influence of anything is illegal. A large majority of the class stopped the instructor and started asking hypotheticals. It seems their general belief was that you have to be actually drinking, smoking, or consuming something while driving. The instructor had to explain it like we were 5 years old. Wisconsin is such an interesting place. Comment 2. To be fair, when I was 5 years old, I had a breakdown that my mom was drinking and driving because she always had a Coke in the car. Like the soda. I was so ashamed my mom was a criminal and I had to tell on her. Everybody I told laughed and no one explained it to me, and I carried that guilt until I was about 10 and figured it out. So when you don't drink and drive, literally, these things happen. Edit. Nice to hear 5-year-old me wasn't alone, but you all had better grown-ups than I did. So glad other people had this explained to them. The lesson here is laugh at your kids, folks, but please also set them straight in an age-appropriate way. Story 4. One of my all-time favorite episodes of Cops back in the day was when a teenager with a permit got pulled over for reckless driving and her father was in the passenger seat drunk as could be. The guy fully admitted he would force his daughter to illegally drive to the bar to pick him up all the time, and he seemed proud of it too. The satisfaction you felt as you watched his face while the officer explained that all of the crimes were in fact his and not his daughter's was one of the most beautiful things I think you could possibly experience. Story 5. I used to work in forensic science and had to testify a lot. One of my coworkers was on his way to testify when he passed by a courtroom that had its door open and heard the attorney screaming at his client, "How can you show up drunk to a DUI trial?" Comment 1. This is similar to the case I was going to mention. Not a lawyer, but I was a witness. The defendant stole the charity pot from a petrol station and caught the back of my car while driving out. The trial was postponed once due to medical reasons, and I had moved house, so I traveled 3 hours from my new place because they wanted to use me to add driving charges to him. The day of the trial, I went out to grab lunch from a supermarket around the corner and saw someone getting caught by security for trying to steal. I went back and was eating my lunch when the prosecutor came in and let me know the trial was cancelled as the defendant had been arrested. Yes, he attempted to steal from a shop while waiting for his trial for theft. In the end, he pled guilty to half the charges, and they dropped the driving ones, so I didn't have to travel down again. Story 6. I worked for a trial graphics firm and was working on a case where a forklift driver was driving recklessly and ran into a cinderblock wall of a new construction. It caused enough damage that a gentleman on a ladder on the second level of the structure fell and fractured some vertebrae. The forklift driver was reprimanded the day prior for driving the forklift in an unsafe manner. In his deposition, he bragged about how many speeding tickets and traffic violations he racked up in his Corvette. It was fun watching the deposition back with the plaintiff's attorney. Story 7. Not a lawyer but was in court to testify. Defendant in another case is pleading guilty. The judge requires him to explain what happened, and he gives a detailed description of his crime. He finishes, the judge looks at some paperwork and says, "Sir, that's not what you're charged with." Comment 1. If you want another one, though it wasn't a criminal trial, a friend of mine had a client answer a question from the judge with, "To be fair, I was on meth at the time." It was a custody hearing. Neither party had mentioned drug use, and neither had priors. My friend had no idea that morning he had ever used substances. Story 8. Client sued for injuries from a car accident. He had about 3 or 4 other accidents within the 3 years prior. One of them was a big rollover accident. He had medical treatment for all of them, but he only disclosed the accidents that were not the rollover. Also, the insurance company saw on his Instagram that he went skiing even though he was complaining about pain in his lower back that was so bad he couldn't walk. We should never have taken the case. I don't know why the office signed him up. Comment 1. I got in a rollover accident once, and the first thing my lawyer said was, do not post having any kind of fun on social media for the foreseeable future. They can be misconstrued into lying about injuries in court, and the case will be thrown out. It was a good deterrent for social media habits in general. I still haven't posted anything since then, and that was like 7 or 8 years ago. Story 9. Child visitation case. Mother argues for less visitation because the father is always late, also in bringing the child to school, and generally unreliable. The father was a whopping 38 minutes late to the hearing. Comment 1. I was going through a divorce with my now ex-wife, and we spent hours of expensive mediation getting child custody, asset splits, visitation, etc. Hammered out. All that was left was to have a hearing in front of the judge so he could rule on the settlement, which is really a formality. Most likely a 5-minute hearing at most. My chronically late ex-wife, of course, was late. We all waited 15 minutes or so, and the judge finally said he was satisfied with the order since everything was settled. She showed up about 5 minutes later and absolutely insisted that we go through the hearing just so that she could say her part on the stand. The judge relented, and once again it was about 5 minutes, but she absolutely had to get on the stand and say her part. Fine. Comment 2. That would have been way early for my dad. Growing up, he was always hours late for everything. If I had a play or a game I wanted him to come to, I'd say it started 2 or 3 hours earlier than it actually did, and he'd still miss most if not all of it. His band nickname was Tony Late, because they'd wait and wait for him, finally start without their lead guitar and backup vocals, only to have him jump on stage several songs in, plug in his guitar, and start playing like nothing happened. The longest he was ever late was over 24 hours, and that was with him constantly telling us he'd already left. He lived an hour away. Story 10. The federal judge asked all the attorneys on a civil case into chambers. He stared point blank at defense counsel and said, "The jury hates you, really hates you." Comment 1. I was in the jury for a sexual assault case this month. The defense's argument hinged on her not using the words non-consensual vaginal intercourse when reporting it to the police. She had said, "He forced himself on me." He kept asking her again and again to say in explicit detail what happened to her instead of letting her use euphemism or anything other than the legal definition of sexual assault. Tip for defense attorneys. The jury doesn't like it when you revictimize the victim in a case. Comment 2. This happened to me on jury duty. They were selecting jurors, and in this case, the defendant was stalking a woman and harmed her. She'd gone to the police for help twice, and they did not do their jobs. Basically, I was saying that my past experience with someone stalking me and the school police doing nothing about it was too similar for me to be capable of being impartial. The defendant's attorney was grilling me, asking what about my experience was similar, if it would impact how I viewed police testimony, why it would impact it, and why my experience with stalking would sway my opinion of the defendant, etc., until I was crying, and the judge had to step in, tell him to knock it off, and then excused me. Story 11. I saw a defendant pulled in for a show cause for violating probation. His drug test had shown positive for cocaine. He stood up and shouted that it was a false positive because he drank 2 liters of coke that day. His lawyer grabbed him to sit down with one hand while facepalming with the other. Story 12. Jury trial. Client on the stand. We'd gone over this evidence dozens of times before. The date of the service of a document was crucial for the entire case. Q. What is the office policy regarding issuing this letter to overdue accounts? A. We do it on the 5th of every month. I was already ready to facepalm here, because the document is dated the 3rd. Q. Exhibit A is dated the 3rd. Why is that? Hoping she would say, the 5th was a Sunday, so we wanted to get it out early. Instead she said, I don't know. It shouldn't be. If the 5th is a Sunday, we are supposed to serve it on the 6th. Double facepalm. Q. But if you dated it the 3rd and signed the proof of service for the 3rd, that would mean you served it on the 3rd, right? Objection, leading. Sustained. Absolutely the correct call by opposing counsel and judge. Q. When did you serve the document? A. I have no idea. Story 13. A man approached the court for a reduction in his child maintenance payments to my client while driving a brand new BMW SUV. He said because I was a junior at the time, he'd handle the case himself and he'd squash me. After his poor attempt at compiling his disclosure of his financials, he was investigated and it was found that he was laundering money through a fake online church. He's now being criminally prosecuted. Story 14. Not a lawyer, but I felt the need to share my own singular sovereign citizen experience. Canadian, by the way. In traffic court, waiting for my turn. A guy is called. He stands up and is dressed and looks respectable. Business suit, clean, hair combed, suitcase. I would have guessed he was a lawyer if he was sitting ahead of the bar. He stands up and says out loud, "Well, I have a driver's license with that name on it, but as it's in capitals you can see that's the name of a corporation, Your Honor." The justice on the bench did his best to be reasonable with this guy. But the guy immediately starts a speech about how the system is corrupt and there needs to be changes. He would go on about that several times in the next while. This first time, the justice says, "That's not what we are here to discuss today. We're here for a speeding ticket. And if the defendant's name doesn't present himself in front of this bar, I'm ruling a conviction in absence." So the defendant hustles in front of the bar, officially presenting himself for the case. Behind the bar is gallery only, and proceeds to start an indignant series of bizarre arguments that were so strange as to verge on delusional. Highlights were: trying to invoke papal law. To which the justice responds, "Papal law? This isn't Rome, that doesn't apply here." Defendant tries to quote admiralty law, which perplexes the justice as, "Where do you get admiralty law? This is Alberta, this is the most landlocked province in the country. Where do you get admiralty law?" The defendant replies, straight-faced and serious, "Well, there used to be a fountain in the basement, sir." Mind you, the defendant hasn't even made his initial plea yet. Multiple times the justice tries to steer him back on track, and the guy keeps responding, "Well, I did it, but that's not the point." So well, after a bailiff has been called to keep an eye on this, and I, witnessing this, have finally realized I wasn't dreaming, the justice on the bench finally says, "Okay. Fine, you've said you've done it multiple times before, and I'll accept that as a guilty plea." Hands out fine and 30 days to pay. Next case. Comment 1. I think my favorite take on the sovereign citizen trying to pull their straw man arguments in court is when the judge says, "Either you are an accredited lawyer, or you are the defendant. If you are neither of these, you don't belong here, and I'm issuing a bench warrant for the arrest of the defendant." Story 15. Third hand, from a friend of the lawyers, in a divorce case. Tell them I only want the boy, not the girl. If I say that, you're not getting custody of either one. I don't care, Your Honor, my client only wants custody of the boy. You can guess how it went. Comment 1. I have a friend whose parents argued for who gets custody of her. Both thought the other should have her. I think she was around 9 years old. In the end, the magistrate asked her where she wanted to go. She said her granny. And that's how she divorced her parents. She changed her surname and her first name and was raised by her granny and a lovely aunt. It's amazing she wasn't more messed up than she was. Story 16. Client was on trial for first-degree harm, and OJ's case looked like a plot from a legal drama compared to this. Nobody has ever been worse at crime in the history of crime. We were appointed counsel, which means we were private employees who sort of offer to be on standby when they run out of public defenders. We were his fifth. He'd fired the 4 prior because they kept telling him to just get started on the life sentence because this was already over. They were right. My client was on trial because he harmed his girlfriend with a pair of gunshots. He did it because she'd secretly ended a pregnancy that might have been his. He found out when he picked her up at the clinic. As they drove home, both of them texted their hour of conversation, including all of his threats to harm her for this when they got home, which he did. My client's apartment building had recently upgraded to full-color, telescopic 4K security cameras. We think he didn't know the upgrade had closed the blind spots. It looked like film from a sports event. My client was also the only 6'4" Hispanic man with bright red hair and a taste for rare, designer sneakers that I and his victim had ever met. This makes it difficult to argue it is not him, while the prosecution plays his crystal clear video on a projector. My client not only used his own firearm, he brought his phone with him while he drove out to the remote spot where it was found. My client also texted his friend to buy him the next one-way ticket to another country, no questions asked. He made sure to give him his credit card to buy it though, because we can't leave our friends on the hook for that bill. Finally, my client had to hide his grin under his hand while the victim's family cried on the stand. The jury deliberated for 43 minutes. Story 17 happened to a friend of mine a few years back in Canada versus Telus. Telus offered a promotion on his contract and he always would call in and say he just wanted his original contract price, which was $15 cheaper than what it was worth now. So every year, he would call in and ask if he could extend his contract by another year. Well, last year, as that price was practically non-existent, they immediately bumped his price up when he phoned in, stating that he was on a glitched account and his original contract was void, because they didn't sign a contract every time they extended it. So they charged him over $8,000 for the plan. But what Telus didn't do, or this representative and this whole department didn't do, is that they should have asked to see the contract he had first, and seen that they did do that, and he had emails, phone calls, dates, letters, and pictures to prove it. So he took Telus to court, hired a fancy lawyer, and sought, I think, the maximum in British Columbia small claims, which is $40,000, for mental anguish, breach of contract, and pressure tactics, and won. The lawyer warned Telus and said, "Hey, I put a lot of evidence into discovery for you guys to comb over. Are you sure you want to pursue this? It's a pretty strong case. I highly advise you look at this." Telus said no need, we have our proof. Their proof? The original contract that had an end date, and their defense looked super smug and happy. My buddy's proof? All the amended contract emails, agent names, dates, phone call transcripts they got from Telus, everything. The judge ruled in my buddy's favor and even made the comment, he gave you a chance. Story 18 Okay, it wasn't my client, but I was prosecuting a case. Third offense driving while intoxicated, reckless driving, negligent use of a firearm, not relevant, but the law on that one needs to change. If you're drunk and a cop found you with it in the car, that's enough to convict, though 99% of the time our office would dismiss that charge for a driving while intoxicated plea. And assault on a police officer. In our jurisdiction, a fourth driving while intoxicated offense is a felony, so a preliminary hearing was required. Those are usually waived since it's pretty clear if probable cause existed in driving while intoxicated cases, but the defendant was representing himself and refused to waive. So I finished my questioning of the officer. Defendant requests cross-examination. First question. Isn't it true you only added the assault charge because when I hit you, you started crying like a weakling? The entire courtroom was stunned. The judge told him to watch his language and recommended that he be represented by an attorney since the question was also an admission. Pretty sure he just wanted to do it for the spectacle. He said no further questions. The judge ruled probable cause existed to continue. He came over to me talking about pleas and we wrapped that up before the end of the day. Story 19 Not a lawyer, but a business acquaintance was being sued over a slip and fall that apparently left this guy permanently disabled and unable to walk. His unscrupulous lawyer turned down settlements and was apparently a nightmare in court-ordered mediation. The whole thing fell apart when my acquaintance's lawyer won a hearing over the plaintiff's motion to exclude video evidence from a private investigator. Guess who was recorded multiple times walking, and once running in the rain, into his lawyer's office? Apparently, the judge ruled in a morning hearing and the case was dismissed with prejudice before the close of business that same day. Story 20 Order of Protection Case. Victim filed. Abuser shows up for court in a suit with sunglasses on. I don't have proof of this, but he was a substance user, so pretty sure he was trying to hide his pupils. Abuser decided he was going to exercise his right to hear what he had done and question the victim. Victim gets up on stand and answers his questions honestly. One of the questions was, "Why are you working with the police to put me under surveillance via cameras in my light fixtures?" Victim responded, "There are no cameras. You're hallucinating." Cue courtroom erupting in laughter, including the court employees. I've never seen a courtroom get so loud in real life and watched the judge start yelling for quiet and banging the gavel. Victim was terrified she had done something wrong and kept apologizing to the judge. At the end, the judge granted the longest order of protection possible via the state, then excused the victim and family. As the victim was walking out, the judge laid into the abuser, lecturing about how much of a disgrace he was to the community and how his parents and grandparents were rolling over in their graves. He should be ashamed of himself. The judge continued this until they determined the victim had time to get into their vehicle and leave. Comment 1. As a juror, I was watching a very expressive witness on the stand being questioned. The defendant was accused of financial crimes against the witness. The witness was speaking Spanish, and an interpreter was interpreting to English. The prosecuting attorney asked the witness if the defendant had paid back the money. The witness rolled her eyes in the most dramatic fashion, waved her hands, and said with dripping sarcasm, "No." The interpreter did her best to have a sarcastic tone when she interpreted into English and said, "No." We couldn't help but laugh until the judge began scowling at us. Story 21. About halfway through a frivolous order of protection hearing against my client seeking visitation with his son, after the woman admitted she wasn't in danger and a friend told her filing an order of protection would keep him from getting visitation. As the judge was scolding her, she blurted out, "I want a lawyer." Story 22. Couple neglectfully allowed their pet ferrets to injure their very young child while they slowly warmed a bottle as the baby screamed for help. Permanent damage to the child's feet and ankles. The ferrets were put down by animal control. Parents wanted to sue animal control over the animals and also try to get their homeowner's insurance to pay the medical bills. This was the first case ever assigned to me. Story 23. My dad was a corporate attorney who occasionally tried cases. His worst experience was representing a racist property manager. The plaintiff was a black nun who was so distressed by the situation that she lost large clumps of hair. My dad had to question her while she cried on the stand with visible bald spots. He felt absolutely horrible, and his client lost. Story 24. I'm not a lawyer, but my mother-in-law's divorce attorney would have a great answer to this. My father-in-law started to suffer from early-onset dementia, which triggered a series of events resulting in my mother-in-law, not wrongly, filing for divorce. Throughout the 3 years of divorce proceedings, my father-in-law's condition became very obvious, to the point he was showing up to court in garbage bags, when his lawyer was able to get him there. By the end of the divorce, he was living in a memory care facility and his sister had power of attorney. When everything was settled, their estate was split 50-50. Yet my mother-in-law insisted he was faking it and that he had hidden millions in offshore accounts. So she sued. She couldn't prove he ever had millions of dollars in the first place. She insisted he was faking it despite several doctors attesting to his condition. So pretty much all of the proceedings were, she's not winning. But she insisted. When their divorce proceedings were finalized, she had over $750,000. By the time her failed attempt to sue ended, she was down to $125,000. Story 25. I was the defendant, not the lawyer. But I'll make this quick. If you're going to try to sue for more than $100,000 for life-changing injuries over a tiny no damage, fender no bender, maybe don't leave your social media public. And if you do, maybe don't upload pictures and videos of yourself rock climbing, hiking, and going to trampoline parks. And for the record, they got nothing. They should have settled with the insurer. They'd have gotten $10,000 to go away. Story 26. This is rather boring compared to other stories. It was a child custody case in a county I don't normally practice in. Mom, my client, wouldn't agree to a rather good settlement agreement and wanted her way 100%. She wanted a judge to decide rather than the parties settling where they both walk away winning and losing in a sense. The hearing starts, and the judge enters. We all rise like you typically do, and the judge unleashes a tirade telling us to sit down. It's obvious we're from the big city all dressed up, but it's his courtroom and he's in charge. Then the judge mentioned his military service, and I knew that minute we weren't going to win this case. The dad was former military. I annoyed the judge by not taking the time to know how he operates his courtroom before appearing in it. The judge ordered a dad favorable opinion. Mom was mad. I learned 2 valuable lessons. The first is that settlement is preferred because you at least have some control over the outcome. And the second is get to know the court you are in. Edit. Most civil court cases are legally nearly 50-50. Both parties have legal standing to present their version of events and proposed remedies based on legally sound arguments. There's only a tiny difference between the two sides. Having a professional relationship with the judge and county bar association can be the difference between winning and losing a case. If there's not much to go on, the judge is going to side with the one person they know because it becomes about character and trusting a lawyer's honesty at that point. It's just a reality. Story 27. My mom's client lost his case because he kept posting his workout videos and pictures to Facebook after his car accident. He just would not stop, and I think he was addicted. Apparently, showing off his physique was more important than his case. My mom had to tell another client not to post vacation pictures of her on a dune buggy in Dubai after her accident, and she was majorly upset about it. Baffling, really. Story 28. Literally any sovereign citizen. Judges will not put up with it. Also, anyone who abuses the kindness of a judge. If a judge gives you a chance to get rid of your case before disposition, take it. Because you will not get many of those, and those are far less serious than a criminal conviction. Story 29. I had a client walk into the Department of Child Services office and demand to be drug tested immediately. They tested positive for almost everything. Still can't figure out what they were hoping to achieve. Comment 1. I was involved in a case like that. The guy had bought some scammy cleanse product off the internet that was supposed to clear substances out of your system and make you test negative. He drank the stuff, waited one day like it said on the package, then went and demanded to be tested. His idea was that he would get a negative test on record as soon as possible so he could then go back out and use a bunch more substances. It didn't work out that way. Story 30. Clients in jail awaiting trial for an unrelated charge. Client decides he wants out of there and stacks chairs in the recreation room. Client climbs chairs, pushes through the ceiling tile, then crawls on top of the ceiling toward the next room over. Client falls through the ceiling 5 feet from the starting point and plummets 10 feet in a shower of ceiling tiles. Client somehow manages to land on his feet. Client grabs fallen ceiling tiles, stacks them on top of the chair stack, then attempts to escape again. Client falls through a different part of the ceiling. All of this is captured on jail video camera. Comment 1. This reminds me of the people who robbed the gun store that was a couple of doors down from my office, in a strip mall. Most entertaining thing ever. This was back in the 1990s. They broke in the back door of the salon to our right, 3 businesses away from the gun store. Went up into the ceiling, fell into our office. Back up into the ceiling, fell into the travel agent's office. Up into the ceiling again, managed not to fall into the CD shop, but then fell into the gun store. Got trapped. I would have loved to have a video of all their falls edited together. But the only one that had a camera was the gun store. Story 31. I'm not a lawyer, but I've seen several clips of the trial of Darrell Brooks. He drove his car through the Waukesha Christmas Parade Inn, resulting in the deaths of 6 people and injuries to over 60. Throughout the entire trial, in which he represented himself, he did nothing but worsen his case while irritating everyone else in the courtroom. The judge absolutely gave him the maximum sentence, ultimately imposing 6 life sentences and an additional 1,000 years with no chance for parole. Comment 2. There's a clip where, with the jury out of the room, he demands to question his ex-girlfriend about their children as he wants the jury to know she's a bad mother. The prosecutor reminds the judge that will open the door to bring in his conviction for statutory offenses. I spat my water when I saw it. Story 32. Not a lawyer, but I used to sell advertising to attorneys. I was walking into an attorney meeting when he pulled me aside and said we'd need to reschedule as he had a bit of a complication going on. I asked him what that was, and he said, well, my client brought his girlfriend to his divorce meeting with his wife. And I went, alrighty, you have fun with that one, and wished him well and left. Story 33. Not a lawyer, but this one always makes me chuckle. A friend of mine rear-ended another vehicle. They exchanged information. There didn't seem to be any damage or injury, and they went on their way. 2 years later, my friend receives word that she's being sued for injuries from the accident. The other party had a sprained wrist and was suing for $25,000 for pain, suffering, loss of wages, etc. So, my friend calls her insurance company, and they say they'll take care of it. Long story shorter, the insurance company offers her $5,000 for her to go away. She insists her injuries deserve better compensation. They offer her $7,500. She still refuses. They offer her $12,500. She laughs and says, "See you in court." And they did, about a year later. Case went before a jury. She won, and was awarded $2,300, 1/3 of which had to go to the lawyer she'd hired. So, instead of taking $12,500 of which she would have gotten 100%, she went to trial and ended up getting 66% of $2,300, so about $1,500, and had to wait a whole other year to get it. Story 34. I'm a public defender. Where do I start? Had a resisting an officer case that was actually a good trial case. Unfortunately, there were certain facts we needed that could only come in through my client, so it was the very rare instance where the client needed to testify. During cross-examination, he randomly blurted out at the jury. The entirely rural, white jury of conservative blue-collar paper mill workers. I thought I was gonna get George Floyded. He could not read the room. Had a client get pulled over for driving at night without his headlights on. The officer gave him a warning and then let him go. And then in passing while turning to go back to his squad car asked, "Oh, you don't have anything illegal in your car, right?" His response? "Nah. You can search it if you want." Pro tip. If you give the cops permission to search your car, they're going to search your car. They found open containers. His blood alcohol content was 0.27. I have so many. Story 35. I was defending the case, so it wasn't my client, but the guy testified very clearly, under oath, multiple times, in no way that could be mistaken, that he was seen by a very reputable specialist who diagnosed him with an irreversible condition that was a key issue in the case. We ended up settling for nothing more than nuisance value, nearly pocket change, but I was holding in my pocket until trial, in case I needed it. That the reputable doctor had passed away several months before he allegedly evaluated this guy. That would have been a fun one to try. Story 36. I'm not an attorney, but I work for the state equivalent of the IRS. My job is to resolve tax disputes before trial, and if they go to trial, I am the state's primary witness. This means I'm subject to cross-examination by the other side, typically the taxpayer. I was dealing with a difficult, agitated taxpayer for an extended period of time. This is common before trial. We try not to go to trial, so there was a prolonged period of me trying to explain why we did what we did. I had some brutal trial prep with our attorneys to get me ready for anticipated cross-examination. To reiterate, I work for the state equivalent of the IRS being a federal agency. I gave my testimony. Then the taxpayer was allowed to cross-examine me. He asked me, why did the IRS disallow his refund? I explained, for about the 5th time, that I do not work for the IRS, and I do not know why the IRS did what they did. He would need to ask the IRS. I was tempted to comment that if the IRS also disallowed his refund, it would appear the state side adjustment was also correct, since we follow federal law. I decided against it. Next, he said, no further questions. Going to trial is expensive. Both sides had to split the costs for the court stenographer, $1,400, so $700 each. During the lead up to the trial, I told him multiple times we are not the IRS. He literally paid $700 to ask me under oath if I worked for the IRS, because apparently my telling him multiple times that I do not, and all of our correspondences being on my state's letterhead, was not good enough for him. I think he may have had some brutal follow-up questions for the IRS, and he was completely blindsided by this revelation. I don't know. The amount at issue was about $3,000, so $700 was a hefty amount for the taxpayer. Of course he lost. We knew we were probably going to win before trial, but when he declined to even ask me any questions which could advance his case, it was clearly over. Story 37. My squad was searching a stash house on a warrant. This was part of a takedown of a violent organization, and there were a bunch of houses being searched at the same time. The house I was in was a known stash for firearms and substances, and during our investigation, one of our undercover officers bought multiple firearms that came out of this house. I was searching the kitchen in full gear when someone opened the back door and popped their head in. I turned around, he looked at me. I looked at him, then he backed out and slammed the door shut. I ran to the door, opened it, and he was standing right there with his hands up. I sat him down on the patio steps and started to get his information while my sergeant ran him through the National Crime Database. The guy was cooperative but wide-eyed and extremely nervous. As I stood there and began to look at his waistline, I could see a clear outline of a firearm in his jacket pocket. My body camera footage showed what was almost textbook printing of the firearm while I stood in front of him. He didn't fight, he just accepted being handcuffed and arrested. Possession of a handgun by a prohibited person. He went to booking, and after getting into the jail, he made a phone call. Keep in mind that the phone system very clearly says all conversations are monitored and recorded. During this phone call, he told the other party that he had a satchel with $700 cash and substances that he tossed over the fence before I came out the back door. A couple of detectives went over there and found the bag. There had been a big snowfall that morning. There were no footsteps anywhere near the bag, and the bag did not have any snow on top of it. Inside the bag was $700 cash, substances, and the guy's driver's license. He filed a motion to suppress. His position was that I had no right to detain him. He lost that motion pretty badly and pleaded out. Our state's attorney cited something like 7 clearly established cases that showed this position was completely wrong. At the end of the hearing, the judge told the guy he was going to put him in an employment education program because he needed to find a new job, because he was so terrible at being a drug dealer. Story 38. Not a lawyer but work in the courthouse. We had a civil trial with a judge and jury, which is super rare for us because who would want the unpredictability of a jury in a motor vehicle collision case? There was a car accident. The plaintiff claimed injuries to his back, spine, neck, head, tailbone, and about 3 other ways of describing back pain. He hadn't initiated the action until a year later because a lot of his symptoms were late onset. Then on the stand while testifying, he admitted something to the effect of, "I wasn't going to bother with suing, but the cost of living crisis has gotten out of hand. I'd like to buy a house, and real estate prices are crazy high, so I'd like the money." Unsurprisingly, this did not sway the jury, who had to give up 2 weeks of their lives for this guy's trial. He lost. So, on top of his financial worries, he was on the hook for the other guy's legal fees. Comment 1. I was a juror in a criminal case. The defendant was charged with aggravated assault with a deadly weapon. The victim testified that the defendant had run away, but the defendant claimed that he had such a severe back injury, he couldn't have run away. During jury selection, the lawyers were conferring with the judge at the bench. In order to face the jury pool, the bailiff had the defendant move some chairs from facing the bench to facing the gallery. This involved lifting the chairs over the table. Needless to say, the defendant was convicted. His lawyer asked us what the turning point was, so we told him about the chair lift. I think people heard the facepalm in the next county. Story 39. I've had quite a few cases doing Social Security disability. Typically, it's people who have gone back to work and didn't tell me, or those who suddenly remember they actually volunteer 40 hours a week once they're under oath. But the most memorable one was the guy who was being questioned by the judge about his substance use, which was noted in his records, and after being asked if he used any other substances, he started listing off multiple ones, pretty much you name it, he'd done it, and then informed us all that he had last used about a month prior. That was a denial I didn't appeal. And it was a very interesting call with his mom when she called me extremely upset about him getting denied and me recommending not to appeal it. The judge had actually done him a favor and completely left out all of the hardcore substance use in the decision so it wouldn't be an issue for him in the future if he got clean and tried again, but that made his mom think that the judge had clearly denied him based on something unfair since he had only mentioned alcohol and marijuana. Comment 1. Tough situation. Your first part reminds me of a case I had while working in Social Security disability at a legal services provider. I inherited the client. We'd represented her on her first losing hearing, and then on the appeal. The district court actually reversed and remanded for a new hearing based on some error or another. In the meantime, they'd gotten a full-time job. Normally, a client we would have turned down, but since we'd already done that much, the bosses said let's stay on the case. I did my best to scrape together some flimsy argument about all the accommodations their work was giving them, extra breaks, etc. That meant they couldn't actually work 40 hours a week. At the hearing, they brought up, against my firm's pre-hearing advice, how they'd recently won Employee of the Month and were actually totally amazing at their job. They still didn't understand why they lost.